I wanted to talk about private rights of action that are found in California legislation. There are a handful of bills every year in the California legislature that create or preclude a private right of action, which are used to enforce civilly the provisions of a particular statute. Now, in most instances, state or local governments are charged with enforcing violations of a statute. But there are some statutes in which a private citizen is granted the authority to lawfully enforce the provisions of a particular state law or laws. Because a private person can enforce the law and file a civil action or a civil suit. This type of provision in a California statute is called a private right of action. And California statutes, as well as bills proposing statutes, either create a private right of action or they prevent a private right of action from existing. So let's look at the two. For private rights of action that have been created, the following I'll read to you as examples from recent bills in the 2022 California legislative session that specify that the bill does create a private right of action. For example, a private cause of action lies against a person who intentionally distributes by any means some sort of unlawful product. Another example is that any person other than an officer or employee of a state or local governmental entity in the state may bring a civil action against any person who does any of the following, and then it specifies. And the third affirmative example is a person may bring a civil action for actual damages, compensatory damages, punitive damages, injunctive relief, or any combination of those, and any other appropriate relief, including statutory damages, against any person or entity that engages in specified activity. The other side of the coin is where no private right of action is allowed. And I've also got a couple of examples here from bills during the 2022 California legislative session where the bill specifies it does not create a private right of action. For example, this chapter shall not be deemed to create a private right of action or limit any existing private right of action. The second example is this chapter does not create a private right of action, period. The third example I found is this division does not create or imply a private right of action for a violation of this division. Let's turn to legislative intent because with the examples that I read above that deal with either specifying that there's a private right of action or stating emphatically there is not one, there are explicit provisions from a statute that could allow or prohibit a private right of action. But in other instances, you might find the private right of action language contained in a statement of legislative intent. And so I found the following example also from a 2022 California legislative session bill. And that bill provides the legislature finds and declares that neither the original provisions of this section nor any subsequent amendments to it were intended to create a private right of action. However, nothing in this subdivision shall restrict or expand the existing right of any party to seek relief from non-compliance with this section pursuant to a writ of mandate. So in all of these examples I've read to you, there's language addressing the question of whether violation of the particular statute may be enforced by a private citizen or not, as opposed to a governmental entity. And in some statutes, either a private party or the governmental entity will be authorized to enforce the particular law.